Assalamu alaikum. We were discussing the Electronic Transactions Ordinance 2002 in our previous lecture, and if you recall, I told you that ETO has basically a dual scope. It talks about other things, but mainly its focus is on two basic things. One, that it provides legal recognition to documents in electronic form, and secondly, it also provides legal recognition to electronic or digital signatures. Right? Now, I also try to explain to you how the digital signature technology works, although we have done this topic quite a few lectures ago. But in our previous lecture, I repeated the concept because I believe that unless you have a fair understanding of the working of the digital signature technology, you cannot understand this piece of legislation. So I urge that you go through that working of the digital signature technology before you try to understand this law. Now, Section 2 of Electronic Transactions Ordinance defines various terms which have been used in this law. So in Section 2, there are quite a few definitions. I have just picked up those definitions which I think are relatively more important. And our policy would be that I would try to give you a summary of a section, and then I would show you on the slide that section itself so that you can see what is the language used by the lawmakers in making this law. And then I think you will be able to make a fair understanding. So Section 2 defines the term certificate. Certificate is the digital certificate which you are familiar with. So you remember that digital certificate establishes the connection between a public key and the holder of that public key. So an individual who has got a public key, his association with his public key is attested through the digital certificate. So the term used, certificate, here is the same. That is, it is the digital certificate you are aware of. Then ETO talks about the certification service provider. It is the same as the term certification authority or CA you are familiar with. So you remember that certification authority is that body which issues a digital certificate to an individual attesting his corresponding public key. So here they have just changed the term. Instead of using the term certification authority, the lawmakers have used the term certification service provider, although it does the same function as the certification authority does. Then there is a term defined in ETO, certification practice statement. So certificate practice statement, basically a policy, is a policy document which a certification authority or a certification service provider would be obligated to prepare and maintain. And in that document, in its practice statement, the CA would highlight as to what is its policy about the protection of the public and private keys, and what is its policy of refund of any payment which a customer or a subscriber has paid to the certification service provider or the CA. So things like that. Certification practice statement is a public document. Every subscriber of a certification authority or a customer of a certification authority would be entitled to receive this practice statement. He can go through various clauses of this practice statement before he can really become a customer or client of a certification authority. Again, practice statement can also include as to the extent of the liability of a certification authority in case a certificate is later proved to be forged or fake, etc. Then there is a term originator. Originator in simple terms means the person who sends an electronic communication. Then there is the term addressee. Addressee means the receiver of the electronic communication, right? Then there is the term information system. Information system would include all such systems which are used for electronic communication purposes, like an email server is an information system, a web server is an example of an information system, etc. Then in section 2, the section pertaining to the definitions, the terms authenticity and integrity have also been defined. So there is not any difference from the concept which you already know. So authenticity means that the identification of the source of a communication can be made, right? Integrity means that the message, the electronic communication has not been altered or modified. It is intact. It is in the same format, the same way as it was originated. So these are a few terms. So let's go to the slide and see what the lawmakers have actually used the language to define these terms. So we start with the term certificate. Certificate means a certificate issued by a certification service provider for the purpose of confirming the authenticity or integrity or both of the information contained therein of an electronic document or of an electronic signature in respect of which it is issued. So as I mentioned, a certificate can be used to establish the authenticity and integrity of an electronic communication. Then the term cryptography services. It means services in relation to the transformation of contents of an electronic document from its original form to one that cannot be understood or decoded by any unauthorized person. So you are familiar with the concept that by using the cryptographic keys, the messages, they can be scrambled, they can be made into a non-understandable format. There is a term accredited certification service provider. Instead of defining the term certification service provider simply, the ETO has used this term accredited certification service provider, and it means a certification service provider accredited under this ordinance to issue certificates for the use of its cryptography services. Let me point out here that under the ETO, there is a body which has been constituted. It is called the Certification Council. It has got 5 members. This Certification Council has been created to supervise the activities of the certification service providers or the certification authorities. It can also do other jobs. It has to maintain a repository database where different certificates are to be stored so that they can be viewed by public. The Certification Council is entitled to issue licenses to certain certification service providers or certification authorities, and then such certification service providers would be called as accredited certification service providers. So once they have got the license, the certification authorities, they would be termed as accredited certification service providers, and then there are certain advantages of receiving this license for the Certification Council which the certification service providers may have. So we'll see what are those advantages in our subsequent discussion. So let's see what other terms have been used. Originator means a person by whom or on whose behalf electronic document purports to have been generated or sent prior to receipt or storage, if any, but does not include an intermediary. So in simple terms, an originator would mean a person who sends an electronic communication, who generates an electronic document, and the originator would not include any intermediary. The intermediary has also been defined in the ETO. So any service provider who sends, receives, or processes the electronic communication, who helps in these activities, can be called as an intermediary. And by the definition of this term originator, an intermediary would be excluded. An intermediary cannot be called as an originator. Then there is the term addressee, which means the person intended by the originator to receive the electronic communication, but does not include an intermediary. Again, the person who receives the electronic communication, he would be called an addressee, and the term addressee would exclude an intermediary. Information system means an electronic system for creating, generating, sending, receiving, storing, reproducing, displaying, recording, or processing information. So you can see that this term is very broadly defined, and it includes almost every type of information systems, including email server, web servers, proxy servers, etc. Electronic signature. Electronic signature means any letters, numbers, symbols, images, characters, or any combination thereof in electronic form applied to, incorporated in, or associated with an electronic document with the intention of authenticating or approving the same in order to establish authenticity or integrity, or both. Let me point out that ETO has used two different terms in this regard. One is the electronic signature, and the other is advanced electronic signature. Right? So the definition of the term electronic signature you have just seen. The advanced electronic signature, which I have been able to understand, is an electronic signature which can be verified through the accredited certification service provider. So wherever there are the accredited certification service providers, there is the use of digital certificates, the use of public-private keys, and using such a mechanism the signatures are executed. They can, in my opinion, be termed as the advanced electronic signatures. And advanced electronic signatures are superior as opposed to simple electronic signatures, in the sense that there is a presumption of truth attached with the advanced electronic signatures. I'll highlight this point when we come to that provision of law. So for the time being, you should keep in mind that there is a distinction between a simple electronic signature and an advanced electronic signature. A simple electronic signature may not use cryptography, the pair of public-private keys, etc., in order to provide authenticity and integrity. There can be some other technology, but an advanced electronic signature would, in my opinion, use the public key infrastructure for the verification of the digital signatures. Okay, then authenticity means in relation to an electronic document or electronic signature, the identification of an attribution to a particular person or information system. So this property authenticity means that you can identify the source, the sender of an electronic document with the help of electronic signature. Integrity means in relation to an electronic document, electronic signature, or advanced electronic signature, the electronic document, electronic signature, or advanced electronic signature that has not been tampered with, altered, or modified since a particular point in time. So in simple terms, you can say that integrity would ensure that a particular message or a particular signature is intact, it has not been tampered, it has not been forged, etc. Okay, let me make one thing clear here, that I don't expect that you memorize all these sections of law, right? This is not my intention. I even don't require that you remember these section numbers. No need for that as regards the examination. For examination point of view, I don't require that you memorize everything. But what I want is that you should have a general sense, a concept, what a legal provision is, what is its main scope, and then you should be able to express yourself in the exam in your own words while sticking to the main sense of that provision. Right? So don't feel uncomfortable that this language is proving to be very difficult. I understand the jargon, the language used by lawmakers is very typical. So I don't expect that you would memorize every such thing, but at least you should have a concept, you should have a feel of how the lawmakers, they do the legislation, what language they use, and that is primarily the purpose why I want you to be familiar with these provisions of law, with the language the lawmakers use. Okay, then there is a term appropriate authority used in the ETO. Appropriate authority, generally speaking, would include the National Assembly, the 4 provincial assemblies, the federal government, the 4 provincial governments, the Supreme Court of Pakistan, and the 4 high courts. Right? So generally speaking, the appropriate authority would include these bodies. Moreover, any organization, any body, any statutory body rather, which is working in relation to a federal government or which is working in relation to some provincial government, that would also be covered under this term appropriate authority. Now this term statutory body may be a new one for you. Any body, any organization, any institution which has been created through a written law, that would be called a statutory body. The word statute means written law. So those bodies, those institutions which have been created by the Act of Parliament through a written law, they would be called the statutory bodies. Okay, I can give you an example here. For example, Law Development Authority, LDA, it is a statutory body. So there is an LDA Act 1975, through which the LDA was constituted. It was formed by the Act of the Provincial Assembly, the Punjab Assembly. And the LDA works in relation to those activities which the provincial government is required to perform. So it is working for the development of the city of Lahore. Okay, it would not be out of place here that I give you some idea as regards the functioning of a state. A state has 3 organs or 3 pillars, namely the legislature, that is number 1, number 2, the executive, and number 3, the judiciary. They primarily work independently, and there is a system of checks and balances which is intended to be created by dividing the functions of the state into these three different organs. Each has a separate role to play in the state, right? So the job of the legislature, the National Assembly, the provincial assemblies, the Senate, etc., their role is the making of law. They are the lawmakers. So the representatives, you and I, we elect to the National Assembly or to the provincial assemblies, they are the lawmakers. They debate, they discuss, and then they pass different laws. Now, the job of the executive is to make arrangements to implement those laws. For example, a law is passed, then it is the job of the executive to ensure that there are certain bodies which ensure that these laws are enforced, they are implemented. Executive otherwise has no role in the making of the law. So it is the job of the government to establish a police department so that the peace and the law and order situation in the country is maintained. The lawmakers have passed a law for that matter that there would be security for the citizens of Pakistan. They would enjoy peaceful living. And in order to ensure that, the Department of Police is set up, and that department is run by or run through the executive. The third organ of the state is the judiciary, the courts. The job of the judiciary is to interpret the laws according to the intention of the lawmakers. So they have to interpret different terms, different clauses of law according to the wishes of the legislature. So the role of the courts, judiciary, is also to settle the dispute between the citizens and between the state and the citizens, as the case may be. In our constitution, there are two legislative lists. The constitution is the supreme law of the land. Every other law in Pakistan is subservient to the constitution. The constitution dominates. If any law is contrary to the constitution, then that law can be struck down by the courts. So I was talking about the legislative lists. What are these legislative lists? The federal legislative list, the first type of list, contains the items or the matters on which the National Assembly alone can pass laws, can legislate. So, in relation to matters related to the defense of Pakistan or the armed forces for that matter, only the National Assembly is to competent make laws. The provincial assemblies do not have the competence to make laws on these subjects. On the other hand, in case of second type of legislative list, which is called the concurrent legislative list, in that case, both the National Assembly and the provincial assemblies can simultaneously legislate or make laws. So, for example, in relation to matters of marriage and divorce, Islamic education, etc., these are the areas where both the National Assembly can make laws as well as the provincial assemblies can also legislate. Now, let's see how Electronic Transactions Ordinance has defined the term appropriate authority. You can look at the screen in this regard. Appropriate authority means, one, in relation to items contained in the Federal Legislative List of the Constitution of the Islamic Republic of Pakistan 1973, the Federal Legislature or Federal Government. 2. In relation to items contained in the concurrent legislative list of the Constitution of the Islamic Republic of Pakistan 1973, for which a federal law is in force, the federal legislature or federal government, and in all other cases, respective provincial legislature or provincial government. 3. In relation to the functions of the federal government or respective provincial governments being discharged by a statutory body, that statutory body. So I gave you the example of LDA, Lahore Development Authority, which works in relation to the Punjab provincial government, and then the LDA can also be called an appropriate authority under this clause because it's a statutory body. 4. In relation to matters in respect whereof the Supreme Court or the High Courts are empowered to make rules for the regulation of their proceedings, the Supreme Court or High Court, as the case may be. So in all those matters where the Supreme Court and the High Court, they are empowered to make certain rules, for example, to make the working of the lower judiciary smooth. The High Courts, they have a supervisory role. So wherever High Courts make such rules in this regard, then the High Courts can be called the appropriate authority. Section 3 and 4 of the ETO mention that the documents in electronic form, they would enjoy the same status as paper documents, and wherever the law requires that a document should be in writing and that document is in electronic form instead of being in paper form, then the requirement of law of a document being in writing, that requirement would be deemed satisfied. Now this word deemed, you should also register that deemed means supposed. So it will be assumed, it will be supposed that the requirement of law has been fulfilled where a document is in electronic form and the law requires that a document should be in writing. So I gave you the example where you send a legal notice to a government body, you want to sue, you want to file a case against a government body. The law requires that first of all you should give a legal notice before suing, before filing a case. And instead of sending that legal notice in paper format, you send that legal notice in electronic form, then it would be said that you have fulfilled the requirement of law, the requirement that the legal notice should have been in writing. That is by virtue of this section of the ETO. Similarly, where you want to send a job offer letter to a person, to a potential employee, and you send that job offer letter in electronic format, then you have sent a valid job letter. Your job letter in the writing format is in compliance with this provision. Similarly, a lease agreement where you document your lease agreement in electronic format instead of putting it in the paper format, again there would be no problem because that lease agreement in electronic format would have the same status as a paper lease agreement would have. Now let's see what these sections 3 and 4 are actually in the ETO. Section 3 states, no document, record, information, communication or transaction shall be denied legal recognition, admissibility, effect, validity, proof or enforceability on the ground that it is in electronic form and has not been attested by any witness. You can see there is another condition that if the document is not attested by any witness, still it would be a valid document. Number 4, the requirement under any law for any document, record, information, communication or transaction to be in written form shall be deemed satisfied where the document, record, information, communication or transaction is in electronic form if the same is accessible so as to be usable for subsequent reference. So as I was mentioning, in case you reduce a document in electronic form instead of putting it in a paper form, then still it would be valid. You will be considered to have met the requirement of law. There is although one condition mentioned that that electronic document should be accessible, should be available for any subsequent reference. If the subsequent reference is there, then that document would avail the proper legal status in spite of the fact that it is in electronic form. Then there is a provision in the ETO which says that in case the law requires that a document should be retained and that document is actually retained in the electronic form, then the requirement of law of retaining a document would be deemed satisfied provided there are three conditions which are fulfilled. Number one, that document, that electronic document should be available, should be accessible for any subsequent reference. Number two, that document should be either in the original form or it should be close to the original form. It should be a copy of the original form, you can say. And it contains all those contents which are there in the original form. And the third is that there should be some document which identifies the date and time of the generation or acceptance of that electronic document. If these three conditions they are met, then any document which is retained, which is kept in the electronic form would meet the requirement of retention of documents under the law. So let's see what the provision actually is. That is section 6. The requirement under any law that certain document, record, information, communication or transaction be retained shall be deemed satisfied by retaining it in electronic form if A, the contents of the document, record, information, communication or transaction remain accessible so as to be usable for subsequent reference. B, the contents and form of the document, record, information, communication or transaction are as originally generated, sent or received or can be demonstrated to represent accurately the contents and form in which it was originally generated, sent or received. And C, such document, record, information, communication or transaction, if any, as enables the identification of the origin and destination of document, record, information, communication or transaction and the date and time when it was generated, sent or received is retained. You may find this jargon to be complicated, but just keep things simple. Try to grab the main concept and try to stick to the original sense. Next is section 7, which provides legal recognition to the electronic signature. So you can see the requirement under any law for affixation of signatures shall be deemed satisfied where electronic signatures or advanced electronic signatures are applied. There is a provision in the ETO which states that there would be a presumption of truth attached with the advanced electronic signatures, and that presumption would not be associated with simple electronic signatures. It means that where advanced electronic signatures have been executed, have been placed on an electronic document, and there is a digital certificate which authenticates the person who has sent that document, then the burden of proof would be on the other side, other party which denies the execution of such advanced electronic signatures, right? Otherwise, the court would assume, if a dispute arises before the court and the issue is whether these are genuine electronic signatures or not, the court would presume, the court would assume or believe that these electronic signatures belong to that person who has got a certificate by a reputed accredited certification authority. Okay? In case the other party still denies these signatures, then the burden would be shifted on that party. It would have to bring the evidence to show that these advanced electronic signatures, they are forged one. This presumption is not available in case of simple electronic signatures. So wherever simple electronic signatures are in place, then a party has to prove that these signatures belong to such party. Then there are such provisions in the ETO which state that no stamp duty will be paid on electronic documents for a period of 2 years or till a time the appropriate authority devises certain measures. Similarly, again, there is a provision which states that the requirement of attestation of any electronic document would also be waived for a period of 2 years or till a time the appropriate authority devises certain measures. The requirement of notarization of document has also been waived in relation to electronic documents. The objective was to provide incentive to the people to execute documents in electronic form, to adopt electronic commerce. Now, let me point out that in our country there is a law called Stamp Act 1899, and this law provides that if there are certain legal documents to be executed, then in relation to these documents, certain amount of stamp duty will have to be paid. So there is a schedule attached to this Stamp Act which describes a number of documents, and there is a specific amount written in relation to those documents which a party has to pay by purchasing the stamp papers of the equivalent amount. It's a sort of indirect tax, you can say, that you have to pay on the execution of certain legal documents. In case you do not print a document, you do not type a document on this printed stamp paper which you purchase, then your document, it is not admissible in evidence. So this is the general law under the Stamp Act, that those documents which are not typed or printed on a stamp paper, then they are not considered by the court for evidence point of view. But here the ETO has given an exemption that if the documents are in electronic form, they are not in paper form, then for a period of 2 years at least, there would be no stamp duty paid. I'll give you an example. For power of attorney, if you execute a power of attorney and you execute it on a piece of paper, you want it to be in the paper form, then you have to print the substance of the power of attorney on a stamp paper of rupees 1000 in case that relates to the sale of some immovable property, some land. This is so written in the Stamp Act, right? So in case you want to execute a power of attorney in the electronic form, then you are not required to purchase a stamp paper worth rupees 1000 to make that power of attorney. Similarly, as I mentioned, in relation to the attestation, there is an exemption. So the law of evidence in our country, which is Qanun-e-Shahadat Order 1984, that is the law of the evidence in Pakistan, its provision states that any document which creates any financial obligation, that must be attested by two male witnesses, right? So in case any such document has not been attested in accordance with the provision of the Qanun-e-Shahadat order, then such document cannot be read as a part of the evidence. So therefore, in case of electronic transactions ordinance, if you choose to prepare a document in the electronic format, then the requirement of two witnesses is not attracted. Similarly, the requirement of notary public, that in case you want to attest a document that this document is a copy of the original one and you want to have an attestation in this regard, you go to an officer called notary public and he attests, he looks at the original one and then he attests, he stamps and he signs, indicating that he has seen the original and this particular copy is that of that original document. So the requirement of notarization has also been waived for a period of 2 years. Let's see what the provision in this regard is. Section 10, notwithstanding anything contained in the Stamp Act 1899 for a period of 2 years from the date of commencement of this ordinance or till the time the provincial governments devise and implement appropriate measures for payment and recovery of stamp duty through electronic means, whichever is later, stamp duty shall not be payable in respect of any instrument executed in electronic form. And then section 11 says, notwithstanding anything contained in any law for the time being in force, no electronic document shall require attestation and notarization for a period of 2 years from the date of commencement of this ordinance or till the time the appropriate authority devise and implement measures for attestation and notarization of electronic documents, whichever is later. So I've already explained what is the meaning and scope of these two provisions. This is a very typical pattern of the lawmakers. The word notwithstanding has a peculiar meaning. Notwithstanding means that without considering any contrary effect, in other words, this provision would dominate, it would override, or it would prevail. The provision which is in conflict with this provision, that would not take any effect and this provision would override. This is because when the legislature, when the lawmakers use the word, specific word, notwithstanding, as has been used in these two provisions, section 10 and section 11. Then there is a section 13 in the ETO which describes that who would be the sender of an electronic communication. What is the criteria to decide about that? So it has specifically been described that a person who himself sends an electronic communication, he would be the sender of that communication, or if he has appointed an agent, a representative, and he has given him the authority to send communication on his behalf, then if such a person sends the communication, then it would be assumed that the actual person who had given the authority, he has as if sent the communication. The act of a person's agent or representative would be considered as the act of the actual principal, the main person who had given the authority. Third is where somebody has used some automated information system which can generate automatic messages on the basis of certain instructions which you earlier feed, then any information forwarded or sent by such automated information system would also be considered as the information sent by the original person, by the actual person. Then the addressee, the person who receives the information, would be entitled to treat it as a valid communication, and he would be justified in taking certain steps on the basis of that receipt of information, provided he does not have any suspicion about the genuineness of that communication. If the circumstances indicate that there is no suspicion, there is no question of any doubt or forgery, then the addressee would be entitled to act upon that information. So let's see what the actual provision section 13 is in this regard. Section 13, clause 1, unless otherwise agreed as between an originator and the addressee, an electronic communication shall be deemed to be that of the originator if it was sent A, by the originator himself, B, by a person who had the authority to act for and on behalf of the originator in respect of that electronic communication, or C, by an automated information system programmed by or on behalf of the originator. Clause 2. Unless otherwise agreed as between the originator and the addressee is to regard an electronic communication as being that of the originator and is entitled to act on that assumption if there are two conditions mentioned. A, the addressee has no reason to suspect the authenticity of the electronic communication, or B, there do not exist any circumstances where the addressee knows or ought to have known by exercising reasonable care that the electronic communication was not authentic. So my dear students, that was the main discussion I intended to do today, and I think you are now heading towards a better understanding of the different provisions of Electronic Transactions Ordinance. Again, I repeat, don't get intimidated. The legal jargon is difficult, it is complicated, it has got its unique features and pattern. I don't expect that you memorize all these provisions word by word. Just gather some basic sense so that you understand what is the law of the land in relation to electronic documents and electronic signatures. Believe me, there is a consensus abroad that the issues related to the business and technology side of electronic commerce, they have by and large been settled up till now. But the experts say that the legal issues are more complicated ones, and there is a lot of potential of working further on this side. So the courts are busy in laying down laying down the laws in this regard. Different legal issues are coming before the courts. The experts are working. They are putting forward their opinions, and then the law is being developed. So a few years back, nobody had any clue what the internet law is all about, but today it is a full-fledged branch of law. Full-fledged master's degrees are now being offered in this just branch of law, the internet law. So that was our discussion for today. In our subsequent lectures, we'll continue with the Electronic Transactions Ordinance. So till then, I say Allah Hafiz.